Hello, everyone, and welcome to another of our Field Fisher webinar series. This is all focused on the Digital Services Act. My name is Alexander Degay. I'm an associate in London, and joining me on the line is Lauriane Sangare-Versac from our Brussels office.
Hello, everyone.
So, as I mentioned, this is what we're calling a bite-sized series. So this is webinar number 1 of a series of 5 that will be hosted by various of our teams from London and Brussels and our German offices and also our Silicon Valley office in California. This first one is an introductory session, and we're going to introduce really 4 key concepts, and the 4 concepts are going to be gone into in more detail in the remaining webinars of the series. As well as the webinars, we're going to have a series of linked blogs, so keep an eye out for those. We've released 2 already. Oh, and just to mention another information on the Digital Markets Act will follow the Digital Services Act. So here's what we're going to talk about today. Lauriane will take you through part 1 about the reform and background, and I'm going to talk about part 2, the actual proposal itself. And just some housekeeping. So in this webinar, you can ask questions. There is a little questions box in your GoToWebinar control panel. You can just type them in there and we will see them. The aim is to get to those at the end of the webinar. If we run out of time, we can contact you directly. And also use the questions function if you have any technical queries, because we have our technical staff also on the line who can respond to you about those. So here we set out some learning outcomes for today's session. So by the end, you should be able to understand the need for reform, the current law, grasp the key elements of the reform, and form some kind of opinion on the proposed measures. So, Lauriane, over to you to take us through the background.
Thank you, Alexander. So since the adoption of the e-commerce directive 20 years ago, this legal framework has remained unchanged. However, over the past 20 years, new ways to communicate, to shop, to access information have developed, and those ways are constantly evolving. So in this context, new risks have emerged for the citizens and the society, and they have exposed consumers to a new range of illegal goods, activities, and content. And this is a worldwide phenomenon, and it has given rise to many legal initiatives at national levels, both in the EU and outside the EU. And in Europe, the European Commission has decided to take the lead on this topic and announced a reform of the digital services. And the goal of this reform is to ensure the safety of users online and allow innovative services to grow. And next slide, please. So we have highlighted 3 main objectives pursued. The first one is to enhance consumer protection. So the current business models have highlighted legislative gaps which leave the users of online services vulnerable. So here, the first aim is to better protect the online users against illegal content and provide them with actionable rights in this respect. The second objective is to harmonize a fragmented framework. So as I said, the e-commerce directive is now 20 years old and not always fit for purpose anymore. And some member states have taken the lead on their hands. And as a result, there is a patchwork of digital legislation unsuitable for the single digital markets. So the second aim is to provide rules by way of a regulation that will apply directly across the EU in order to streamline the online providers' liability rules, to offer consistency across the 27 member states, and to provide enforcement mechanisms at EU level. And the third objective is to update the liability regime of the digital service providers. So here it's really about giving them more legal certainty and clarity about their responsibilities and obligations, and thereby leveling the playing field among online providers. Next slide, please. So on this slide, we have highlighted the main dates and events related to the release of the Digital Services Act proposal. So it started in 2020, in January, where the European Commission published its work program. Under the second priority, A Europe Fit for the Digital Age, the European Commission announced its intention to put forward a Digital Services Act package. So initially, it was a package composed of two main pillars. The first one, a reform of the e-commerce directive's provisions. And this has become the Digital Services Act. It turned the e-commerce directive into a regulation to create new rules for intermediaries. And it's important to understand that the e-commerce directive has not been repealed, but just amended by the Digital Services Act. And the second pillar was the introduction of an ex-ante instrument covering gatekeepers. And this has become the Digital Markets Act, which is a competition tool that we will not address during this presentation. So in June, the European Commission published two incident impact assessments and ran public consultations to get the views from European and non-European citizens and organizations. And these evidence were used to identify specific issues that may require EU-level intervention in the context of the DSA and the DMA. In October, three committees of the European Parliament also released their resolutions to the European Commission. And the goal here was to deliver a clear message to the Commission on the Parliament's expectations. However, they were not legally binding, so not all the measures proposed subsist in the version of the European Commission. On the 15th of December, the European Commission published the Digital Services Act proposals and the DMA proposal. And from the 16th of December to actually today, the 31st of March, the Digital Services Act proposal went through a feedback period where all the stakeholders can provide their views. And at the end of this feedback period, the European Commission will summarize all the feedback and provide them to the European Parliament and the Council with the aim of feeding into the legislative debates. And the Commission aims to have both texts adopted in their final versions by early 2022 after they have been examined by the European Parliament and the Council. And we expect the DSA and the DMA to come into force in 2023 at the earliest. And when it will become EU law, it will not enter into force in the UK, as the UK is no longer an EU member state. And last slide, please. So we expect many debates at the Parliament and the Council, and we have highlighted three of them. So first question that will be raised, what is the illegal content that the member states and the European Union want to fight against? So contrary to the e-commerce directives, which refer to illegal activity but without defining it, the Digital Services Act will introduce and define the concept of illegal content as any information that does not comply with the Union law or the law of the member states. So it means that the DSA will cover information that are illegal in nature, for example, illegal hate speech, terrorist content, but also information that relates to illegal activities. For example, sharing images that depict child sexual abuse or the use of content infringing IP rights. And some member states have already expressed their views that this does not go far enough and that they want harmful content to be included as well. Second expected debate: how far can the EU go into this fight without impacting the freedom of expression? So some of you may think that the Digital Services Act does not go far enough and that other measures should be proposed to better meet the DSA objectives. However, if we do so and that we strengthen the measures, will the freedom of expression still be preserved? And to illustrate this, some of you may have heard of the recently aborted Avia bill on hate speech. It was in France last year. And this bill required a series of manifestly illegal content on the ground of race, religion, disabilities, or sexual orientation to be removed by some online intermediaries, which were supposed to be defined by a decree, within 24 hours from notice. And failure to meet this deadline was exposing the online intermediary to a fine up to 4% of their global annual turnover. And this bill has been invalidated by the French Constitutional Court on the ground that in light of the deadline and the fines, the bill provisions could only encourage the online intermediaries to remove the content reported to them, whether or not it was manifestly illegal. And last question, should the DSA proposal consider regulating the targeted advertising more strictly? So you remember when I said that the European Parliament released its resolution to the European Commission, it asked the Commission to consider introducing rules in favor of less intrusive forms of advertising. However, the European Commission in its proposal just included measures to make targeted advertising more transparent, but not less intrusive. And 1 month ago, the European Data Protection Supervisor, the EDPS, called the European legislator to consider a phase-out leading to a ban of targeted advertising based on pervasive tracking. So here as well, we expect a lot of debates. And I'll hand it over to you, Alex.
Thank you, Lauriane. Keep an eye on those. Okay, so I'm just going to briefly take you through the what we consider the 4 main aspects of the proposed legislation. And the first one is its scope or extent. So as with lots of these European laws, it's useful to think both in terms of the material scope, so the subject matter it covers, and also the territorial scope, its geographical extent. So as you heard from Lauriane, the e-commerce directive is not being repealed, but just amended. So the old wording around information society services remains. So if you remember, those are defined as services normally provided for remuneration at a distance by electronic means and at the individual request of a recipient. That was not really clear over the last 20 years as services online have developed, whether that definition would include social media networks or collaborative economies such as Uber, app stores, comparison tools, totally free services such as Wikipedia, or those in the freemium model. So part of the need for reform is to be clearer about who it covers. So as well as the definition of information society services, the DSA is really aimed at these intermediary services, which it defines in 4 levels, each of which is a sort of subset of the level above. So I've listed them there. We have intermediary services, hosting services, online platforms, and very large online platforms. So although there's no specific material scope article in the proposed regulation, the aim is that these 4 levels will make things a lot clearer that it does apply to all the services that I mentioned, app stores, marketplaces, and so on, ISPs. And a lot of the obligations, as we'll come to, are tied to these definitions. So the sort of bigger you are in this scale, the more obligations you have. And then in terms of the territorial scope, there's a big change here. So unlike the e-commerce directive, which was based on the establishment criterion, i.e. Where the business subject to the law was established, the proposed Digital Service Act is on a user residence criterion. So that is where the establishment or residence of the end user. So it can be an individual residence or it can be a company establishment. So it's a clear parallel between the GDPR here compared to the old e-privacy directive, no, sorry, data protection directive. So rather than where the equipment or company is located, it's where the individuals are located. So essentially expanding protection to individuals in the EU, no matter where the service provider itself is based. So next, we'll briefly cover liability. So there were exemptions under the e-commerce directive, which remain under the proposed Digital Service Act. There's no real change in two of them, but a focus on harmonization. And then there's a slight change in the third one. So for a bit more detail, the mere conduit exemption, that's where the provider was just a passive transmitter of information. So they had no liability for traffic delivered over their network. That remains. The caching exemption is similar. It's where you sort of temporarily store information to make the exchange more efficient, and that also remains. The hosting exemption, there are some changes here. So that's where your service just stores the information of content providers, and you have no ability to control what's uploaded, but you do have the ability to remove it. And so where you have no actual knowledge of illegal content, but then you are made aware of it, you have to act. So that's change. There's no general monitoring obligation in the proposal, but another good change is that voluntary own initiative, sort of Good Samaritan style investigations are allowed. Under the old existing law, that can lose the exemption if you're actually seeking out harmful or illegal content. And the only exception to this exemption is where in situations where the platform is appearing as a trader. So some platforms where you are buying items from a third party, but the platform makes it look as if they are the one selling, then the exemption doesn't apply in those situations. And just a reminder then that the focus is on illegal content and not harmful content, which is not the case for the UK's similarly proposed legislation, the Online Harms Bill, which tries to regulate harmful content as well. So in terms of the due diligence obligations, so these layers I'm trying to represent the increasingly narrow obligations as you go down the 4 levels here. So these are the 4 categories I mentioned. The idea is that the obligations should be proportionate. So if your service is relatively unobtrusive, the due diligence you have to do is relatively minor, whereas as you increase up the scale, your obligations are increased in line. And so they're all cumulative. So everything applies to number 1, and then only the number 2 ones apply to number 1 and 2, and so on. So for all intermediary service providers, they have to establish a single point of contact, and if they're established outside the EU, then they need an EU representative, and there's some basic transparency reporting obligations. If you are an intermediary service, which is also a hosting service in level 2, then you have to do everything in level 1, and you also have to have established a notice and action mechanism for taking down or alleged illegal content. And you also need to provide notification to the user whose content you're removing with reasons why it was removed. If you are an intermediary service, which is also an online platform, then you have to apply with all of the above, and you need an internal complaint handling system. You need to set up an out-of-court alternative dispute resolution mechanism. And there's a system so you can have trusted flaggers. So those who are seeking out illegal content, you need to give their opinions priority. And then some additional requirements for transparency for online advertising. Then finally, if you are a very large online platform, which is currently defined as those with more than 45 million active users in the EU, so about 10% of the population, so the very large giants only, they have to comply with everything I mentioned previously, but they also need to have systemic risk assessments and mandatory external audits. And there are some data sharing with regulator obligations, and they need a compliance officer to be appointed. So what's the point of the new law if one cannot enforce it, I hear you ask? So the enforcement, of course, gets a lot of the headlines when these proposals are announced, and it remains to be seen whether they end up in the final text. But at least at present, the plan is to have sanctions, so that can be financial and non-financial. The idea is that there will be powers to have on-site inspections, powers to insist on interim measures, so actions to be taken. And then the big financial penalty is proposed to be 6% of global annual revenue or turnover. So that's higher than the GDPR maximum, but not as high as a competition maximum, but still very significant fines. And then at the moment, they propose periodic penalty payments. So if you actually don't pay the fine, there are sanctions for not doing so. And the bodies involved, again, it's going to depend what level of that, the category you are in. So for 1 to 3, that is the intermediary services, hosting and online platforms, the plan is to be regulated by a national regulator, so member state level. They're currently called National Digital Services Coordinators. And then only if you're in level 4, so that's the very large online platforms, then it will be the European Commission itself. And then we mentioned cooperation. So the idea is there will be a European board for digital services set up, and they themselves won't issue fines, but they will coordinate with the other national regulators, issue guidance, practice notes, recommendations, and so on. So if you're familiar with the GDPR setup, very much like the European Board for Data Protection and their relationship with the national or state level regulators there. But worth mentioning, unlike GDPR, there is no one-stop shop mechanism. So that's the brief run through of the Digital Services Act. I just paused to mention here, as Lauriane said, there is the parallel instrument, well, not really parallel, but specifically for the very large providers, the Digital Markets Act. We're not covering that here, but the plan is we'll have some similar webinars or blog series on that. So watch this space. Yeah, this is the second pillar we mentioned. They love pillars in European legislation. So as a result of this, we hope that you now understand the need for the reform, you grasp the key elements of the reform, and you might have started to form an opinion on the measures of the DSA proposal. So that brings us to the end, and we have a few minutes left for questions. So do send those through if you have any questions for us now. There are a couple here. Lauriane, perhaps I'll ask you first because I've been talking quite a bit.
So I'll take the one on will some inconsistency between member states' laws remain?
Yeah.
So yes, in the sense that the member states will have their words to say on some topics. So we quoted the sanctions, for example. This will be an area left for the member states to decide on the penalties they want. Also very important on the definition of illegal content. From one country to another, depending also on the culture of the country, the definition will be different. And yeah, I'm thinking also with harmful content, as you said, Alexander, each country can have its own regime in its own laws on that aspect as well. So yeah, there will remain some discrepancies even with this new regulation.
Yep. Unfortunately, there always seem to be, despite aims for harmonization. Okay, let's see. There's another one here. I can take this one. How will you keep a fair balance with fundamental rights such as freedom of expression? Okay, well, that's a good one. I think, well, it is a balance because obviously the internet allows people to express themselves freely, and that's a fundamental right. But there must be some limits on that. It can't be an absolute right because, as you can see, illegal content or even arguably harmful content can cause a lot of harm in the real world. So what the Commission has tried to do here is just have a very wide approach. So it doesn't specifically target anyone. The idea is it's a horizontal piece of legislation that applies equally to all suppliers. And in terms of giving too much power to remove content, well, built into legislation, there is a right to redress. So if you're someone who's had a post removed, you get told the reasons why, and there is some form of complaint mechanism. You can either complain directly to the provider, or there's the dispute resolution mechanism I mentioned, or you can take them to court. So it's a balance. So there are some mechanisms in there. We've got a minute or two left. Do you think you have time for one more, Lauriane?
So I can take the one on the will the Digital Services Act be compatible with the protection of personal data? So the Digital Services Act has been designed to be in compliance with the GDPR. Yeah, I quoted earlier the opinion of the EDPS on the Digital Services Act, and here we see that the EDPS wants to push for some more clarifications on the compatibility. And if I recall well, there was this example of when the online intermediaries identify and remove illegal content, they have to do so in compliance with the data minimization principle. The EDPS wanted that to be included directly in the text of the DSA.
Okay, great. Well, we're coming up to the end of the half hour, so apologies we didn't quite get to all the questions. We will follow up individually with those who remain unanswered. So just to finish by saying thanks once again for attending. Remember, this is one of 5. The next session I've detailed there. So if you're in California, where it's being broadcast from, it's 8 a.m. Otherwise, 4 p.m. for me in the UK and 5 for everyone in mainland Europe. If you want to get in touch with us individually, our long, complicated French names are on the screen there. And then you can find all these webinars. They'll be uploaded to our YouTube channel. So hope to see you again on another session. Thank you.
Goodbye.